Hello, and welcome to another edition of Smith Debnam's Creditors Corner, where we talk about all things related to banking and consumer financial services. Be sure to hit subscribe so you never miss an episode. I'm Karen Enlow, and I'll be your moderator today. Today's podcast will explore how judgment creditors can use judicial liens as leverage for collecting their judgments. But before we begin, I want to note the information provided in this podcast does not and is not intended to constitute legal advice. Instead, any and all information shared is for general informational purposes only. Listeners should contact their attorney to obtain advice with respect to any particular legal matter. Now, with that out of the way, let's turn on more exciting things and turn to this week's topic. Today's guest is Joe Davies, who's one of my partners in the firm's construction and leasing group. As a member of the firm's construction law group, Joe represents construction companies and small business owners in lease negotiations and complex litigation matters. His clients include general contractors and subcontractors, as well as property managers, landlords, commercial tenants, equipment rental companies, and building materials. Welcome, Joe.
Thank you.
Joe, today I want to talk about a new unpublished opinion from our North Carolina Court of Appeals, Chisholm Construction versus Elliott, as well as how judgment creditors can use their judicial liens to collect their judgments. So can you tell us a little bit about Chisholm?
Yeah, the court's ultimate holding was pretty narrow, and it was basically just a confirmation that what we call judicial liens follow real property, even if it's been transferred from one owner to another. And so that's really what the case held.
Was that surprising? I mean, I've always thought that kind of to be the rule.
That it is. It's a pretty long-standing rule, and it was not surprising that that's what the court held. I think the reason that it even had to be decided was the facts of the underlying case were fairly strange, and there were two lots at issue, and a couple of transfers, and a deed of trust here, and then a judgment later, and so. I think the facts were a bit confusing, and the Court of Appeals kind of narrowed down exactly what it wanted to focus on, and reached that ruling, and kind of confirmed that for a lot of us creditor attorneys that still is the rule.
So when you're talking about transfers, are you talking about the property being sold from one person to another?
It can be sold from one person to another, or in any case in which there is some kind of a deed, whether it's a sale or gift, anything like that. But the typical way it would come up would be a sale.
So why is that important?
Well, for anybody that gets a judgment against an individual or a company, quickly learned that collecting on those judgments can be difficult. But one of the biggest leverage points that we have is that every judgment in North Carolina automatically becomes a lien on real property that the defendant owns in that county. And you can do what's called transcribe a judgment, which basically means you take it from one county to another where the defendant may have property, and then it becomes a lien there as well. And so it's a lien just like any other. And the easiest analogy is like a mortgage. If you've got a mortgage on your house, you have to pay off the mortgage before you can sell it to somebody that takes it free and clear. A judgment lien acts exactly the same way. If a judgment debtor tries to sell their property to somebody else and doesn't pay off the lien, the judgment lien, then that lien stays with the property. And so the typical practice is, somebody that's selling their house, the buyer will force them to pay off any liens, whether it's a mortgage or a judgment lien. And so getting back to where I started, the reason it's important for us as creditors attorneys is there is no other mechanism that's quite as easy to collect money on is when a judgment debtor wants to sell their property to a willing buyer, and they've got to pay you off before they can do it.
Kind of brings back the importance of title insurance and title searches, doesn't it?
It really does. And what's interesting is it can come up in ways you wouldn't even expect. After this case came out and after I wrote the article, I had a case come up where a bank, one it was planning on foreclosing on a property that it had a deed of trust on, and instead decided to take a deed in lieu from the debtor Well, the debtor just happens to be somebody that we had a judgment against, and the bank came to us and said, look, we could go through the foreclosure process and wipe out your lien, or we'll pay you what it would have cost for us to go through the foreclosure. And so, our client wound up getting something for essentially nothing that otherwise didn't have any value because of the fact that the judgment automatically attached to property.
Now, does that work different for individuals than for corporations? Talk a little bit about the difference between property owned and tenants by the entirety. Explain to our listeners what that means.
Sure. So property can be held in a number of different ways. And North Carolina is a state where a married couple can hold property, as Karen said, as tenancy by the entireties. And what that means is a judgment against the husband or a judgment against the wife does not attach to the property if they own it as tenants by the entireties. It would if you have a judgment against the husband and the wife together. But that's one way. If you are married and you have property and somebody gets a judgment just against you, they cannot actually come after your real property as long as you continue to hold it as tenants by the entireties.
Well, that kind of brings back to the point that with our creditor clients, it's always really important to make sure that we get proper security for the loans, including the right guarantors, right?
Absolutely, the right guarantors. And if you've got a contract with owners of property for, if you're as many of our clients are, in the construction industry, and you want to make sure that your judgment lien or your mechanics lien will be effective, you've got to have both parties on that contract.
Joe, are there any other considerations our listeners ought to be considering if they're creditors in either the application for credit stage or on the back end on the collection end?
Well, I think in terms of on the front end, as we talked about, making sure that if you're focused on real property at the end, that you make sure you think about that at the beginning, and at the end of things, what this case reminds us, and as you mentioned, is the importance of title searching. If you are thinking about extending credit and you are banking on their real property as being an asset, it would help for you to know what other liens may be out there, whether judgment liens or mortgages, things like that. And the other thing that the court was very clear on is if one of these, judgment liens, if you wind up trying to buy property at one of these judicial sales or something like that, that you only get whatever that judgment debtor had when the lien attached. And so that is another very important consideration, and another, as you mentioned a moment ago, another reason for the title search is to make sure you know exactly what you're getting.
What do you mean by that when you say that that you only guess what the judgment debtor had? Are you talking about what real property they owned, or what exactly do you mean?
I mean, you only get the interest that they had in that real property. So in this case, in the Chisholm case, there was a deed of trust that predated the judgment. And that was really, I think, what caused all the confusion in the case, is what effect that would have, because the person that held the deed of trust was also the person that ultimately got the property itself. But whoever goes and buys, if there is a judicial sale foreclosing on this judicial lien, then if there's a deed of trust on the property that predates that judgment, if you go in and buy it, you buy it subject to that deed of trust. And so if there's a default on that deed of trust, then the bank can come in and take it from you, just like they could from the original owner.
So if you're second, you stay second.
Exactly. If the judgment lien that attaches is second, then whoever buys it, takes it free and clear of that judicial lien, but whatever was first stays first.
Okay. Well, hey, Joe, thanks for joining us today. That's been really interesting. Is there anything else you want to tell us about?
As I said, it was not a surprising decision. It's an important one that kind of reconfirmed for all of us something that, as you said, we all thought we knew. And that's always a good thing, but also just a good reminder to make sure you know what you're getting when you're buying some property.
Well, thanks for joining us today, Joe, and thanks also to our listeners. If anyone has questions, they can reach out to Joe directly. His email is jdavies, JDAVIES, at smithdebnamlaw.com, and his direct dial is 919-250-2238. If you've enjoyed this podcast episode and want to hear more, please subscribe. Additional episodes are being added constantly. Thanks, and have a great day.